messages sent to me directly. I'm not quite sure how to answer them, so if you send them through to Jessica, she can monitor them as they go. I'll share my screen with you. This is the presentation. If you can't see it, let us know. But this morning, I'd like to talk to you through a range of contaminated land issues, and I'll focus primarily on issues that arise for councils where council owns or occupies contaminated land. And the reason I chose this topic is that councils are large landowners, and whilst much of council land are reserves and parklands which don't have a contamination profile, or if they do have a contamination profile, the risk is very low. Most councils will also have
Central Avenue, Oran Park.
Will also own operated land. Sorry, I missed all of that. The councils will also own land which is significantly contaminated or may have been contaminated as a result of past use. Now, this issue became significant for Yarra City Council in Victoria when the Metropolitan Fire Brigade sued the council for $17 million after the Metropolitan Fire Brigade took ownership of the land. Now, although it's a Victorian case, the facts in this case are very interesting, and what I want to do is take you through the facts and then attempt to apply them to New South Wales law so that you have an idea of how this case might have been considered if it was a New South Wales council. Now, just as a side, the case was commenced in April 2010 and it wasn't determined until September 2015, which gives you an idea of how complicated some of these contaminated land issues and contaminated land sites can be. But the general timeline is this. The history and ownership and use of the site spans back over 100 years. And in July 1980, 450 Burnley Street, Richmond was assigned to the City of Richmond as part of the Crown Grant. Now, between 1914 and 1960, the City of Richmond used the site as an abattoir quarry with a powder magazine, a stone crushing plant, and a brick refuse destructor and tar distilling plant. The site also included a masonry storage tank for coal tar, which had a capacity of 40,000 gallons. And that masonry storage tank was used to store coal tar that the council used in road repairs. Now, in 1961 to 1968, the council leased the site to a private body who used the site as a quarry. In 1993, the former abattoir buildings and all the related structures were demolished, and this included filling in the old masonry storage tank that was used for coal tar storage and putting a cap over the top of it. Now, the 22nd of June 1994 was a significant date in Victoria because it was the date that councils, including the City of Richmond, were amalgamated, and Richmond became part of the Yarra City Council, which was constituted as a new council by ministerial order, which was very similar to the proclamations that have recently been made in New South Wales. So the material point here is that the amalgamation occurred after the site was used or the site was contaminated. In February 1996, by order of the Governor and Council, the State of Victoria revoked the Crown Grant and ownership of the site reverted to the Crown. Now, this is significant because the State of Victoria didn't compulsorily acquire the site, so the Council was not compensated for the site and didn't have an opportunity to consider the uses to which the site could be put given the history of the site. The Council simply lost ownership and therefore also lost control of the site. In 2003, the Metropolitan Fire and Emergency Services Board, who was then occupying the site, undertook some due diligence and lodged a planning permit with the council to build a new community safety and training facility worth about $3 million. It used the site for a while, but on the 24th of May 2004, it entered into a contract with the state of Victoria to purchase the property for $7.73 million, and that was a price that was discounted by about $1.1 million for remediation costs that might have been necessary. And in purchasing the site from the state of Victoria, the Metropolitan Fire Brigade entered into a release in indemnity in relation to the contamination. Now, in August 2004, the council granted the planning permit, and when the council assessed the planning permit, it did not consider the historic records that it had with respect to the past use of the site. Now, even if it had looked, it would not have found much, because not all the records of Richmond City Council were easily accessible, and the records that were accessible were publicly available because they were typically resolutions or minutes of council meetings. In July 2005, the Metropolitan Fire Brigade halted construction work because a test hole had identified coal tar in a bluestone pit, and the remediation costs at that time were estimated to be $12 million in remediation costs. After some years, after the Victorian EPA got involved and issued orders and the site was remediated, the Metropolitan Fire Brigade then came seeking $17 million from the council as the polluter of the land. So the question in these facts is, how might a council be liable? Well, given these facts, council can be liable for exercising a planning function, and this can include preparing or making, in the New South Wales context, an LEP or a DCP, attending a pre-DA meeting, assessing or determining a development application, and furnishing advice in a Section 149 certificate. The council might also be liable in exercising other decision-making functions, for example, in exercising enforcement functions for illegal work or exercising other enforcement powers. Council can also be liable for carrying out activities on land that it owns, for example, landfill, waste transport, former gasworks sites and depots, particularly depots where the council stores fuel or substances used to construct roads. And councils can also be liable if it owns land. Now, I do want to recognise that there are statutory exemptions or protections in New South Wales for councils, but these protections are not a complete answer. So, for example, Section 145B of the Planning Act, the Environmental Planning and Assessment Act, is a protection that applies to the application of a council's planning function. And it essentially says that anything that a council does or omits to be done in good faith is protected. And a council, so that raises the question, what does it mean to do something or to act in good faith? If the council is the polluter from a past use, or after selling the site approves a development consent, has it acted in good faith if it hasn't considered its own past use of the site? Now, a council is typically taken to have acted in good faith if the thing was done or omitted to be done substantially in accordance with contaminated land planning guidelines in force at the time the thing was done or omitted to be done. But that raises another question. What does it mean to do something substantially in accordance with the contaminated land guidelines? And in my view, this creates a real legal problem. One of the issues with the current contaminated land guidelines, or sometimes referred to as the SEP 55 guidelines, is the language used in the guidelines itself. The language used is often expressed in suggestive rather than mandatory language. So here I've got on the screen two examples of paragraphs from the current managing land contamination guidelines, and you can see that it uses words like might or should as opposed to what the mandatory language of, for example, must do something. So the second paragraph, for example, says a remediation action plan or a plan of remediation should be based on the information from investigations and on the proposed land use. The objectives of the remediation strategy and the recommended cleanup criteria should be clearly stated in the RAP, and the RAP should demonstrate how the proponent of their or their consultant proposes to reduce risks to acceptable levels to achieve the cleanup objectives of the site. Now, this second paragraph was discussed at length in the Land and Environment Court in the decision of the Australians for Sustainable Development versus the Minister for Planning. And in that case, the applicant sought judicial review of two decisions of the Minister to grant approval to two projects at Barangaroo. And the projects involved excavation, remediation and construction of a basement car park and early works for the Headland Park. The main factual question was whether the remediation action plans were prepared in accordance with the guidelines for specifically the RAP for the car park. And this was an important requirement in Clause 17 of SEP 55 that all remediation work must be carried out in accordance with a plan of remediation prepared in accordance with the SEP guidelines. Now, the Minister argued that the guidelines are just that and that they should be applied with a great deal of flexibility. However, Justice Biscoe disagreed and said that although this language, this language which isn't mandatory is unhelpful, the intention of the guideline is that there should be the word should be interpreted as must. That is, he placed a strict interpretation on the way in which the guideline was interpreted. And he ended up saying that the legislative provisions that exempt governmental bodies from legal liability as a result of the exercise of a statutory power should be narrowly construed or should not be carried further than a jealous interpretation will allow. By analogy, the principle of statutory construction should be applied to the SEP 55 guidelines, which are incorporated by reference to section 145B. So the lesson here, or the caution here, is that even though there are statutory protections for acting in good faith, the statutory protections will be very narrowly construed and may not be a complete answer to council's liability for dealing with land that it owns, occupies, or land that it has itself contaminated. Now, there are other statutory protections in the Civil Liability Act that protect public authorities, and also there are some personal protections in section 731 of the Local Government Act, which are not intended to deal with too much today. But going back to our $17 million claim, there were really two heads of claim made by the Metropolitan Fire Board. One related to statutory claims, which were the costs, the statutory cleanup costs, and also the breach of statutory duties not to pollute. And the second head of claims made by the Metropolitan Board dealt with the council's negligence in the management of its planning powers and also the management of its own land. So if we look at the statutory claims first, the EPA, the Victorian EPA, issued an order on the Metropolitan Fire Board to clean up the site. And the relevant act in Victoria says that where a person remediates a site in accordance with an order issued by the EPA, it can seek reimbursement of those costs from the polluter or the person who abandoned the substance on the site. Now, when this matter came to court, the council said that given the paucity of evidence and given that the records of Richmond City Council were so scarce, the court could not conclude that the council itself was the polluter of land and it may have been one of the council's tenants one of the tenants that the council allowed to use the site before the 1960s. Secondly, the council said that the council could not have been said to have abandoned the pollution because the state effectively revoked the Crown grant and took the land off the council without compensation and without much notice, which meant that the council was really put in a position where it couldn't do anything with the contamination that was on the site because the site was taken outside of its effective control. Thirdly, the council said that, and interestingly, the pollution occurred before the relevant acts commenced, and that the acts that now regulate contamination and pollution can't apply retrospectively. And we'll deal with that issue shortly because it's quite important. And fourthly, the council said that it could not be held liable for the acts and omissions of the City of Richmond because the proclamation which amalgamated the council did not have the effect that the City of Yarra was necessarily liable for all of the acts and omissions of the City of Richmond. Now, when the court applied all the claims to the law, the court concluded that there was no plausible explanation for the tar being on the site other than with the permission of the City of Richmond. So the court was able to infer that the City of Richmond was the polluter, even though the Crown grant was resumed. So the City of Richmond was the polluter. Now, even though the Crown grant was resumed and the land was taken off the council, the court also concluded that council had abandoned the contamination, and it should have at the time that the land was resumed by the state, informed the state that the land was contaminated and taken active steps to remediate it. Now, the discussion around whether the current acts could apply to pollution that occurred prior to the commencement of the act is important. The council's argument was essentially that the existence of the contamination was lawful because there were no acts in the early 1960s which prohibited the conduct of polluting the site. And the court said that while there is a general presumption against retrospectivity, a distinction can be made between the regulation of a future conduct on the basis of past events and the imposition of liability on a person which did not have, that the person did not have prior to the act. So, for example, putting that in the New South Wales context, the council would not have been liable under the Protection of the Environment Operation Act for polluting the land, or if waters were polluted, breaching Section 120 for polluting waters, because that section or that offence provision didn't exist at the time the land was polluted or contaminated. However, the Contaminated Land Management Act is directed, even though it deals with past events, it's directed at future acts. So if the EPA issues an order and directs somebody to do something on the land to clean it up, that's a future act which deals with past events. And the order, and there's no reason why an order can't be issued in those circumstances. That is, the issue of there being a general presumption against acts applying retrospectively doesn't really apply because what we're dealing with is future acts. And finally, with respect to the proclamation, the court concluded that there were issues with the drafting of the proclamation, and in particular the definition of liability. The proclamation, which amalgamated the council, essentially said that the liabilities of the City of Richmond became the liabilities of the Yarra Valley Council. However, the word liability is a word of art in the sense that it has to be defined and it can mean different things in different contexts. In this case, the court concluded that the definition of liability wasn't very robust and probably didn't encompass all of the types of liability, all the heads of liability that Richmond could have been liable for when the amalgamation occurred. But the court also concluded that the clear intention of the proclamation was that the city of Yarra would take over as if it were the city of Richmond, and on that basis the city of Yarra became liable for everything that the city of Richmond had done. And so the council wasn't successful in the technical point. So the second statutory claim, in terms of the council's exposure to the liability, in this case the council lost in the sense that it was required to reimburse to the Metropolitan Fire Board the costs of remediating the land on the basis that it was the polluter, and the Metropolitan Fire Board had to comply with the notice issued by the EPA to clean it up. And a similar result would likely occur in New South Wales under the provisions of the Contaminated Land Management Act. The second statutory claim was whether or not the council had breached a statutory duty not to pollute. And this it would be a claim that would be made under the Protection of the Environment Operations Act, POEO Act. And in this case, the court said that the council had not breached the duty not to pollute land for a number of reasons. One is the relevant provision didn't apply at the time that that the pollution occurred, and secondly, even if it had, the Metropolitan Fire Board wasn't entitled to bring a private action against the council for breach of the statutory duty. And that's similar to the New South Wales POEO Act, where essentially only the EPA or another appropriate regulatory authority can commence proceedings for offences unless there are special circumstances and unless the Land and Environment Court has specifically granted permission for a private right for a breach of the statute to be brought. So those were the two statutory claims. Now the negligence claims, and this is perhaps the most interesting and relevant part of the case. The first, there were 4 claims in negligence. The first was that the council had failed in its planning functions when it had approved the permit to allow development on the site. The second is that the council had failed in its duty to prevent pollution, and that failure was to future owners of the site. The second claim was that the council owed a duty to future owners of the site to manage the demolition, to make sure that the demolition occurred in a manner that reduced the contamination profile of the site. And the fourth was that the council had a duty to future owners and occupiers to disclose the contamination that it knew was on the site. Now, with respect to the planning function, based on the facts, the court concluded that the council did not breach its duty to the Metropolitan Fire Brigade in exercising its planning functions. The reason the court made this decision was that even though the City of Richmond held some records about the tar contamination from the early 20th century, that does not necessarily mean that the council is deemed to have knowledge of all of those facts and circumstances. In particular, it doesn't mean that the council officers who were assessing the planning permit were aware or reasonably to have been aware of the records that Richmond City Council had with respect to the previous use of the site. The court said that all the planning officers needed to do was to comply and consider the relevant planning controls and the equivalent in Victoria to SEP 55 in considering and approving a planning permit. And importantly in this case, and the reason why this case failed particularly, was that the plaintiff, or the Metropolitan Fire Brigade, was not a vulnerable plaintiff in the sense that it had complete control of the site, was able to undertake extensive due diligence before it lodged its planning permit, and had control of who could access the site to do the relevant tests to determine what impacts might have occurred by past uses. So the case might have been determined differently if the land had remained in the council's ownership and the council approved development on the site and had not done its own due diligence about the contamination profile of the site. So because the court found that the planning officers that were assessing the application didn't necessarily know the council's past use of the site, and because the Metropolitan Fire Brigade was not vulnerable and had the resources to do extensive due diligence and had complete control of the site, the council was found not to have failed in its planning function. The court also found that the council did not have a duty to future owners of the site to prevent pollution. This was a novel claim made by the plaintiff, and essentially the court concluded that you can't owe to a duty to a group, to a hypothetical potential purchaser or owner of the site in the future, because that would inhibit the council's right to use its own land to fulfill its own functions. So there is no duty to future owners to prevent pollution. The third negligence claim was a duty to future owners and occupiers to manage demolition in a way that ensured that the contamination didn't spread throughout the site, and the court concluded that the council did not have a duty to ensure that the demolition contractor it engaged conducted the demolition with reasonable care and skill. The final negligence claim, which is perhaps the most interesting, is whether or not the council had a duty to future owners and occupiers to disclose that the site had been used as a tar distilling plant, including a tar storage tank. The court held that there was no duty, and the reason the court held that there was no duty is that the council had no relationship of landlord and tenant, and as we discussed before, the Metropolitan Fire Board wasn't a vulnerable person to the council. So this might have been different, for example, if the council was itself selling the land to the Metropolitan Fire Brigade and knew that the land was contaminated. So there might be a duty to inform if the council has reports which demonstrate the extent of contamination and makes a positive decision not to disclose those reports to a potential purchaser. But in circumstances where the land was resumed by the state, the council had no positive duty to warn future owners and occupiers of the site that it had used the site as a tar distilling plant. Now, the negligence claims in the case in Victoria failed essentially on the facts. But what I want to do now is take you through the general principles of the common law claims of negligence and nuisance so that you can apply them to the facts of any council, of any of your council-owned or occupied sites that might be contaminated. Now, in order to understand the liability at common law, it's necessary to understand the nature of the contamination on any particular site. Now, we know that contamination does not respect subdivision or site boundaries, and it's always necessary to identify the source of contamination, whether or not there are any exposure pathways, and what the different environmental and human receptors are to the contamination. With respect to legal risks, there are two common law areas of concern. There's negligence and nuisance. So negligence exists when a person owes a duty of care, breaches the duty, and the victim suffers damage. Now, negligence can exist for both acts and omissions. That is, you can be negligent for putting a substance into the ground, and you can be negligent in failing to contain the substance in the ground or manage it, even if putting it in the ground wasn't negligent in the first place. Now, nuisance is an issue where the contamination continues to exist on another person's land, and the existence limits or restricts the person's ongoing use or enjoyment of land. And generally, the remedy here is to obtain an order from the court to remove the nuisance. So, for example, in this picture here, The nuisance might be that the contamination plume has extended under somebody's residential property, and that nuisance is having the effect that the residential users or the people that own the house can't have their children play in the back garden because of the risk of exposure. And in those circumstances, the court will order, or will typically order, that the contamination be removed entirely, or at least to a standard where the adjoining neighbour can continue to use the land as they are entitled or intended to. Now, in order to understand how these common law principles of nuisance and negligence apply, it's necessary to think in multiple dimensions involving time, that is, when was the contamination caused, when was the impact, what was the state of knowledge at the time, the location, is the contamination on council land, is it off council land, is it migrating, the impact, who is impacted by the contamination, are they employees, is it council's own land, is it private land, are industry and business impacted, or are the receptors environmental receptors, flora and fauna, or other ecological impacts. And finally, who caused the contamination? Did the council cause the contamination, or did somebody else? And even if the council did cause the contamination, did somebody else contribute or change the profile by exacerbating or undertaking construction works or doing something to the contamination after the council had originally put the substance in the ground or in the water? Now, the categories of negligence are never closed, but in considering if somebody is negligent, you take all of those dimensions, all those facts, and the court will put them through the following tests. Is there a relation? What is the proximity between the council and the person claiming to be impacted? That is, what is the relationship between the polluter and the person who suffered damage? Did the person who suffered damage rely on the polluter? Now, typically a court will conclude that the public are entitled to rely on a public authority not to pollute, or if there is pollution, to do everything reasonable to address the risks. That is, there's a reasonable presumption of reliance on a council that doesn't exist between two private landowners. Secondly, knowledge of the hazard is a key element. So when did the risks become known? And this is particularly an issue in managing historic contamination, where the substances used might not have known to be dangerous, or where the substances were stored in a manner which was at the time thought to be the most reliable or best manner of storage. Thirdly, the court will consider whether or not the damage was reasonably foreseeable. The court will consider the court will consider the ability to foresee the consequences of not checking or removing the contamination. Now, reasonable foreseeability is an area where environmental reports play a key role. If the council has engaged an environmental consultant to study or look at or identify and characterise or monitor contamination, if the environmental report makes recommendations for further testing or certain other actions, if those actions
Sorry guys, I don't know what's happened here. 1 second.
I don't know. Okay.